Clearly, what stands out from this conversation is that we are getting very misleading claims about what exists in other countries. And what also stands out is the fact that certain restrictions are guided by legal statutes, judicial oversight, and also aggrieved parties rather than state control, where they can avail certain remedies. Social media companies are for constant restriction. Social media companies are approached, they take certain actions themselves. So it's not a state-governed, state-controlled system as it is being made out. As we go further, find out more about the firewall, of course, we have to keep in mind that Pakistan also has a constitution, as mentioned in this conversation, Article 14, Article 19. How these are to be interpreted and applied matter, even if we have a lack of rule of law, but we still have to uphold certain fundamental rights. Hello, my name is Farieha Aziz, and you are watching a digital rights series for DawnNews English. Today, I have with me Faisal Daudspotha, who is an attorney based in Dubai, and he's originally from Karachi. Thank you, Faisal, for joining us. The conversation today specifically is about the firewall, the elusive firewall that we are hearing. And the defense of the firewall that is coming from some ministers and even people from the industry is that it exists in the US and UK and GCC countries. And we just want to check out these claims, whether this really is true that there are state-controlled firewalls regulating content on the internet in these countries. Faisal, can we begin with you commenting on the fact that US, UK, GCC countries, as mentioned by some people, that there are state-controlled firewalls here?
Thank you for having me, Farieha. Glad to be here. Going straight on the issue. So United States does not have a firewall per se. There have been a series of statutes that were struck down under the freedom of speech clauses in the states. The only things that they monitor, they don't, there are three things when you're talking about firewall. Essentially two things: surveillance and filtering or censorship. And you can go into internet traffic management, and you can look into the violation of sundry a whole bucket of laws. You can look at that. But essentially, when the firewall is in place, you're talking about surveillance, you're talking about controlling the content, which is affects the speech. Surveillance affects the privacy. These are the two rights we are talking about. In other countries, when you are talking about firewalls, they don't target these specific areas of civil liberties. They are looking at pornography, child pornography, or stuff like communication decency, as they call it in US. They have a Communication Decency Act, which enables the law enforcement authorities to monitor content which is offending and offensive to community standards of morality and decency. Or they have a system of notice and takedown procedures for intellectual property infringements. So they only look at these two main areas. The third one that came in, which is relatively fresh, is sort of hate speech reaction, which is a private right. If somebody is suffering something of prejudice because of somebody's hate speech or stalking on the internet, they can go to the court and seek relief against those kind of infractions. Other than that, they are not looking at controlling the content, or they are not looking at doing a surveillance. They have this so-called FISA Act. They have a Section 702 in the FISA Act, which is Foreign Surveillance Act in substance of foreign nationals, whether they are in states or outside the states. But Section 702 can be construed to be broad enough to include the Americans within that scope. That's why they have had litigation on that, and the American Civil Liberties Union has litigated on that already, and they continue to educate people that there are risks around that Section 702. Other than that, there is no mass surveillance firewall that has been sanctioned by any law in the states. There has been leaks previously, and they were subjected to judicial scrutiny, and that's where it stands in the states. So in UK, as I understand, they have had this Human Rights Act of 1998. Again, it protects the two rights, which is privacy and freedom of speech. UK doesn't have a constitution, So they took out these ideas from the European Charter of Human Rights when they were part of the European Union, which means the Human Rights Act primarily dictates what kind of civil liberties need to be protected and where the state limitations kick in when they're talking about somebody's privacy, surveillance, or somebody's freedom of speech, or they're trying to control the content, or any prejudices caused because of those. But what they have an Office of Communications that give issues guidelines. They have certain laws that look into, again, the communications decency, which is child pornography or intellectual property rights or hate speech a little bit. They talk about insult. They rely on the Defamation Act of 2013 also, where the private parties can sue the other private parties, but they do not remove the due process in the whole process. So they have more of guidelines for self-regulation rather than statutory obligations which restrict those essentially two civil liberties under the guise of a firewall. So they don't you don't call them firewalls. They are laws that enable the government to look into infractions supported by the legal. There has to be a reasonable suspicion for that to happen, and they have to subject themselves to go to the court, or in case of some serious infractions, which is child pornography. One of the elements that they have is also incitement to crime and all this stuff. So you can also look into that as a process of monitoring. But to enact a mass surveillance firewall, that would be attracting scrutiny under the Human Rights Act that they will face back in 1998. That's when it was established.
So what you're saying is that typically there are legal instruments, so there are statutes, there are specifically defined categories of speech where certain restrictions or limitations may apply. There are processes. Now, how do you compare this with what you see play out in Pakistan, whether it's the firewall, because there's actually been no disclosure, and also generally when we see PTA's actions with respect to content or the internet, or the FIAs for that matter, under PICA, and so-called there is a statute, but the way that it gets implemented, how do you compare this with other countries where due process and rule of law does prevail?
Here's what I see. First of all, they have, there are conflicting messages coming out whether the firewall exists or not. And if it does exist, whether it's a hush-hush issue, don't talk about it, let it be there because it would attract scrutiny. And if somebody goes and knocks at the door, court door, they would find it challenging to justify how it works. Firewalls in countries where you have certain civil liberties guaranteed is something of a challenge to establish, something of a challenge to operate, something of a challenge to justify. Now, what you see, those civil liberties, when you talk about these things in the Pakistan, you have these two rights where you call the right to privacy, which is inviolable, subject to law. Then you have a right to freedom of expression, which is freedom of press, which is with reasonable restrictions subject to like 7-8 categories, which can be subdivided more. Now, the Constitution provides the basic document for certain guarantees of rights, which means when you legislate beyond that or under that Constitution, you have to enhance those rights over the years so that people can cherish and enjoy their rights in a much more profound manner, in a much more liberating manner, in a much more progressive manner. You cannot use the pretext of subject to law or subject to reasonable restrictions to abridge those rights. So the Constitution provides the baseline for which you have to go beyond and above in enriching the experience of those rights, rather than you have to find exceptions to take away and abridge those rights and make it miserable for the people not to be able to enjoy those rights. So when you come, in certain spheres, freedom of speech cannot be criminalized because it's a fundamental right. You are exercising a fundamental right. You cannot be criminalized for that. So the laws that Pakistan has over the years, which starts from the telecommunication regulation, section 54, which is the one you had the recent notification of that, for interception and surveillance. Then you have the PICA Act of 2016. Before that, you had the Investigation into Fair Trial Act, which actually the two subject matters are surveillance and interception. That's essentially the main document that covers the regulatory system for surveillance and interception in Pakistan. With those things already happening, now they have come up with this the latest issue of saying that they are setting up a firewall. These two rights that I just mentioned, they will be the essential linchpin to justify or not justify these things. Now, when we talk about content control, there is an element under the free speech thing, we call it a prior restraint doctrine, right? There's a censorship. So if somebody has done something wrong or said something wrong, you can sue them for damages or defamation, for example. This is after the fact. The compensation is, somebody has been defamed and he's prejudiced. Okay, he needs to be recuperated. So he's going after the fact for compensation. But if censorship happens before you speak, that is where the prior restraint comes in. In one of the Urdu slangs, you call it zaban bandi, right? Zamabandi. So you cannot put people on mute just because of the fact that you anticipate that what they will say will be critical of you. Same goes with the Defamation Act of the Punjab. Actually, that has the same issues around it also, in addition to a host of other irregularities under the Constitution. So when you set up a firewall and you're talking about content filtering or removing content before it is published or automatically removing content when it is posted, that's where the prior restraint doctrine kicks in under the freedom of speech doctrine. So there will be a strict scrutiny of that, whether it serves a narrow purpose for the state or whether it takes away civil liberties in mass for the entire population. So that's, the court will be doing a balancing, and it will be very difficult to justify when you are talking about essential civil liberties, which is freedom of speech. Same goes for privacy. When the surveillance is happening, the most recent judgment from Babar Sattar, which is one of the orders in a series of orders that he's seized of a case about surveillance and audio leaks. So he has given out that lengthy decision where he's saying that the mass surveillance of 4 million people is or 440 million people, something like that he's touched on, is illegal, unconstitutional, and there's no foundation for that. So anybody who comes in to say that they have set up a firewall, they won't be able to justify that under Article 14, under Article 19. Article 14 being the right to privacy, where it would say, okay, subject to law does not mean subject to reasonable restriction. Subject to law means you have to amplify the rejoicing or enjoyment of the right. So, and right to privacy is inviolable. Inviolable means it's a technical term used from the Victorian era English, which means it cannot be disturbed, which means it cannot be violated, which means it cannot be changed. So right to privacy cannot be reduced. Right to privacy, because the Constitution doesn't say subject to reasonable restrictions. That qualification doesn't exist in the right to privacy. That only exists in the right to free speech. So surveillance would be very hard to justify on various pretexts, because the Constitution does not give you any qualification on any subject matter or any pretext to qualify the right to privacy or to reduce the right to privacy. So any setup of a firewall will run into serious constitutional challenges in Pakistan, and there will be a very hard scrutiny of that by the courts, and there will be a very hard time for the legislator to justify that or the state to defend that before the courts. Courts have nothing else except these two fundamental rights to ask them what is happening.
So lastly, are there any jurisdictions that you have come across where, of course, striking the balance is a difficult thing to do in today's age of social media, but is there any example you've come across where it comes close to balancing rights where restrictions are concerned?
Of course, there are few ways that the states have addressed that. You have Australia, you have US, of course, you have neighboring country India. In Australia, what they did, they set up, they are not looking at national security is not an issue for them. They have an e-safety commission that set up a way of receiving grievances, which is an executive body, part of the federal executive government, that when there's issue of stalking, when there's the issue of hate speech, when there's a issue of harassing, when there's an issue of defamation, you can go to the E-Safety Commission and lodge a complaint against that, and they would scrutinize that, put the other party on the notice, and then when the other party is able to defend it within a reasonable time, it's okay. If they are not able to defend it, they will ask them to remove that offending online content, and they will notify the social media companies that according to our regulator, there is a deadline for that to remove the offending online content. Now, this is being done by the regulator after putting both the parties on notice, right? It's not that, it's not happening ex parte, that somebody came in and the content was taken down and the person was subjected to the gallows or something. There is no incarceration happening in the process. It's just that they're regulating, they're looking at communication where one person has agreed with somebody else's assertion or statement. It can be true or false. Now, if the regulator, E-Safety Commission, makes a mistake or is biased or is passes an order that is illegal, for example, what happens to that? That goes into appeal before the court, which means the court then does the scrutiny on the basis of the second-tier scrutiny of fundamental rights or the rights of the parties concerned. So there may be 90% instances where offending content is immediately removed after the orders of the E-Safety Commission, but the 10% content would still be going to the court, where there would be competing interest of two. It can be two competing organizations. It can be two competing narratives also. It can be difference of opinion between conservatives and liberals also. It can be also that. So there will be certain niche areas where it will go to the court. There will be another example. I already gave you the example of US. In India, there had been a couple of cases. One was on Facebook, where the content control and privacy was heavily discussed. Then that was in 2022. Then back in 2017, there was a case of K.S. Puttaswamy versus the state of India. I think I have that. And in that one also, the right to free speech and privacy was heavily discussed, and they laid down the guidelines. That's why their Information Technology Act was the one that was scrutinized under that case, and they found it difficult to justify that. Then they're still struggling to sort out how to deal with the regulation of internet. But easy example is that of Australia. Of course, their studies have been done by the Europeans also, and they have to look at like 27 countries and in one go, and most of them are pretty liberal in their outlook when it comes to certain liberties. They are much more liberal than other conservative. I would categorize the Australian legal regime as slightly conservative compared to Europe. So Europe brings in guidelines, but then you look at certain countries which do provide laws to restrict certain kind of speech, like in Germany, when you are talking about the Nazis. Of course, there are laws that would restrict you from certain philosophical ideas to be promoted in the press, which is dated before the internet times came about. Same goes for Japan. Of course, they do deal with the decency issue, but the Emperor time Japan and the issues around it, they tend to look at it under their laws, also under the penal code, that there is no misleading information around that also. So people have gone to courts on those issues, but the state doesn't come in and hammer down on you that you haven't, you should better shut up and don't talk about it. That's not how the privacy works or the free speech works. So the trying to censor something before it has been uttered is something that is would be very difficult to justify for the state. That would be the prior restraint.
Great. Thank you so much for making time for DawnNews English as part of the Digital Rights series. Clearly, what stands out from this conversation is that we are getting very misleading claims about what exists in other countries. And what also stands out is the fact that certain restrictions are guided by legal statutes, judicial oversight, and also aggrieved parties rather than state control, where they can avail certain remedies. Social media companies are apply for constant restriction. Social media companies are approached, they take certain actions themselves. So it's not a state governed, state controlled system as it is being made out. As we go further, find out more about the firewall, of course, we have to keep in mind that Pakistan also has a constitution, as mentioned in this conversation, Article 14, Article 19. How these are to be interpreted and applied matter, even if we have a lack of rule of law, but we still have to uphold certain fundamental rights. Thank you for joining today.